Hey everyone! Today I present to you Mr. Glenn Shack. He is a garbage human being who was arrested on charges of possession of CSAM. The El Dorado Police Department arrested him following a report they received from the National Center for Missing and Exploited Children, alleging the exploitation through the use of electronic devices. After an investigation on the tip, EDPD arrested Mr. Shack for 3 counts of aggravated internet trading in CP. The charges were filed for the Butler County District Court, and Mr. Shack is appearing in front of Judge Rickey. Since that time, the case has been an absolute shit show, and Judge Rickey, by the end, has had enough. I don't think we've ever seen Judge Rickey mad before, and this is quite interesting. Let's start at the beginning.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Glenn Shack. It's case number 2023 CR 435. Cheryl Pierce appearing for the state of Kansas in the Butler County Attorney's Office. Chris Pate is defense counsel. Defendant Shack appearing from the Butler County Detention Center Zoom location. This matter comes before the court at this time for hearing on a defense motion to reduce bond. I might just make the observation, Mr. Pate, in looking at your motion, that Butler County is in the 13th Judicial District. I have a certain reticence to be connected with the 18th. So just thought I'd make that correction. But this is properly before the Butler County District Court on a motion to reduce bond. The court noting that first appearance notes would indicate that Judge Satterfield at that time established bond in this case at $100,000 cash or surety with conditions of no internet, no possession of pornography, and no contact with children under 18. I'll also make the observation that the charging document in this case charges 3 counts of off-grid person felony. Well, I'll take that back. The first 2 counts are the same, and indeed the third is aggravated internet trading in child pornography, off-grid person felonies. Mr. Pate, the court is familiar with the contents of your written motion. What would you add to the written statements that you made in your motion?
I'm sorry about the case caption, Your Honor. That's what happens when I file these with little oversight from my legal assistant. She usually is good about catching that stuff. But in any event, Your Honor, I don't have a ton to add to my motion. I know one of the things that I think may have been discussed before I was involved was that Mr. Shack had some connections to the state of Texas, and I think it may have been stated by Judge Satterfield or elsewhere that they were concerned that he was going to be a flight risk. I've been able to talk with Mr. Shack, and he is confirmed with me he has no intent of returning to Texas. As I noted in my motion, prior to his arrest, he was working at True Lies and Villa Rose Construction, which I believe is a construction company owned by the person that owns True Lies. He has no intent of leaving the state. He would agree to reasonable electronic monitoring conditions that he doesn't leave the state as part of any bond. His wife does live in El Dorado as well. I've spoken with her a couple of times. So he does have housing here in El Dorado. He does have employment. As I've noted, he does not have any type of criminal history that I'm aware of. Mr. Shack also left me a lengthy message yesterday indicating that if he gets out, he's working, I think, to get some counseling and mental health services set up through South Central Mental Health or somewhere else here in town. I am aware these are serious off-grid charges. As I've read the affidavit, which is really all I've got to read yet, I don't think these involve contact sex offenses or anything of that nature. I don't believe Mr. Shack has any reason that he would be around any children under the age of 16 or 18, and we would certainly agree to a condition that he not as a term of bond. He simply can't make the bond that's set, and even if he could, I know he's been in contact with some bondsmen, and with a bond that size, a lot of them want the defendant to sign over their house or other significant asset to help secure the bond. And Mr. Shack doesn't own the type of property that could be used as that type of security for bond. So we're, as noted in the motion, we're asking for a $15,000 cash or surety bond, or any other amount the court deems appropriate. In looking at this, if this is something that does head in the direction of trial, I anticipate it could involve computer experts and things of that nature that could take some time to evaluate the evidence, which could lead to this case possibly taking a little bit longer to get to trial than a typical case as well.
All right, a couple of questions for you, Mr. Pate. You state that Mr. Shack is a Butler County resident. How long has he lived here?
It has been off and on. I believe he was here for, correct me if I'm wrong, Glenn, about 6 months prior to your arrest. Is that correct, Glenn?
3 years total.
I'm sorry?
3 years total. I was going
3
to
years.
Texas for a year and 2 years before that, and 6 months before the arrest, yes.
Okay, so you were an El Dorado resident for 6 months consecutive prior to the arrest.
And in Andover, Butler County the whole time. I've never lived anywhere in the state other than Butler County. That's where my CDL's out of, my truck's insured, my truck's plated, everything's here in town. Yeah.
Well, he also said, Mr. Pate, that he was living with his wife in El Dorado. They weren't together before?
They were separate for a period of time when he was down in Texas, but as I understand it, they were living together at the time of his arrest.
I was driving over the road. Wasn't hardly ever home. I was only home a couple days a month type deal. So as far as not being separated, but yes, she's lived here. She has a El Dorado driver's license.
All right. Ms. Pierce, what is the state's position regarding this bond reduction request?
Well, Judge, I don't think that, first off, I have a little bit of an issue about what is being said about where he lived or he didn't live. As I recall, this particular case actually started back in June when it was first initially came over and law enforcement got involved in this. At that time, he was living in Texas, and in fact, there were some criminal charges in Texas, which were is how they verified that in fact he was in Texas and lived in Texas. So I'm a little bit unclear about what it is that he's saying about what his contact is with or was with Texas. I don't think that in light of the severity level of offense that the bond in and of itself is unreasonable. The amount is unreasonable. They are off-grid felonies. Those are presumptive life imprisonment upon conviction. And so, as I said, I don't think that in and of themselves, they are unreasonable. So I just don't know that in the court in making that decision, it did anything that was arbitrary or anything of that nature. The fact that he can't make that, I understand that he does have a right to a bond, but at the same time, when we look at the nature of the offenses and the number of the offenses, I just don't think that the court acted without reason. So if the court's inclined to, in fact, to reduce it, I would ask for some kind of EMD or some kind of restriction that would be put in place so that we could have some assurances that he would not leave the county and those kinds of things, Your Honor. I don't have anything further, Your Honor.
All right. Well, Mr. Pate, I think it's problematic that your client works construction. I mean, I doubt seriously if he works construction all in this local area. Who knows exactly where he's sent to do construction work? He could be in any number of counties at any time. Isn't that true?
I think it would be, and I don't know if he needs to be restricted to the county, restricted to the state. Absolutely. I have no issue with that. And I don't know how wide of a range that construction company has. I mean, I'm sure Sedgwick and Harvey County would be the closest. Beyond that, I'm not sure where they would go. Can you address that, Mr. Shack?
That is that Sedgwick County is typically at some here in Butler County, but those are the only two counties I've ever worked for hauling asphalt millings. That's it. And then the restaurant, of course, is right here in town, and that's where I do the predominant of my work. Goes to the restaurant.
So, and with that in mind, I don't want to say anything that my client doesn't want me to, but if he would accept a restriction to Sedgwick and Butler County, I could offer that as well as a proposed bond condition.
I think there is, to a certain extent, a distinction between pornography cases and one where there is an accusation of actual harm, sexual perpetration upon a child. While one often leads to another, I'll also note that under our constitutionally based system, Mr. Shack does have a presumption of innocence of these charges. And I agree with Mr. Pate. This is not the kind of case that has a tendency to sail through the system. Number one, the stakes are so high because these are off-grid felonies. It obviously creates a suggestion, at least, that Mr. Shack could be a considerable run risk. And I think that's probably what was in Judge Satterfield's mind when she set the original bond in this case. However, the court also wants Mr. Shack that if he is inclined to seek any type of professional assistance for any personal problem that he may have, I want to encourage that rather than to discourage it. Further, the court does want to be fair when it comes to the issue of bond in this case. The court will reduce bond in this case, but not nearly to the extent which is suggested by Mr. Pate's motion. I will set this essentially in accord with what the legislature determined years ago to be an appropriate bond for the most serious of drug cases, often dealing with manufacture and possession of certain components of methamphetamine manufacture. And they set minimum bonds at $50,000. I think that that figure is appropriate for this case, which essentially cuts the bond requirement in this case in half. But the court will have some specific restrictions. Number one, I'm going to follow Judge Satterfield's lead regarding that he is not to be in possession of pornography, quite obviously. And he's to have no contact with children under 18. I think to some extent to simply say he does not have access to any internet services to be overly broad. And I want to remove that as a restriction, but I'm going to add a very significant one. And that is, I'm going to restrict him to the geographical territory of Butler County, Kansas, and Sedgwick County, Kansas. And the only reason that the court is willing to extend his location to Sedgwick County is because there is a number of treatment and therapy services available in that county, which may not be available here. And just to encourage this defendant to seek whatever services, though I'm in no position to know exactly what, that he might on his own individually seek, I do want to open up the potential market of Sedgwick County to him as well. And I'll also note that Mr. Pate's office is located in Sedgwick County, and I want him to have the ability to be able to go to his attorney's office. So I will restrict his geographical location to be monitored with an electronic monitoring device that he has to pay for to Butler and Sedgwick counties only. And here's what that means, Mr. Shack. If you step your foot across the line into Greenwood County or Harvey County, you're in violation. And I'm not going to keep you on a long leash here. You make a mistake on this the court's going to consider it insecure about your ability to follow rules, and I'm probably going to take action on your bond. So I will reduce the bond in half to $50,000 with the restrictions announced, particularly electronic monitoring device as a specific condition to monitor his location and restrict him to Butler and Sedgwick County only. Obviously, you must appear for all scheduled court dates on time, Mr. Shedd. And further, I'm going to require you that if you make bond, and I know it's still considerable, if you make bond, you must appear either in your attorney's office, Mr. Pate's office, or the alternative at the Sallyport location located at the Butler County Judicial Center. I'm comfortable with your participation from either one of those locations, but no other location. So either at the Sallyport, on the south end of the building, the Judicial Center in El Dorado, Kansas, and we're in Mr. Pate's office. All right. Any questions about any of that, Mr. Shedd? Mr. Pate, I'm going to task you with the responsibility of drafting an order, reducing the bond, but setting restrictions as ordered by the court. I do want all specific restrictions listed in the order. Obviously, no contact with any, well, there's no real alleged victim here, I perceive. I trust there's no allegation that he actually knew any of the subjects which might have shown up in any of the pornographic images which are evidence in this case.
No,
Ms.
Your
Booth?
Honor. No,
Okay,
Your Honor.
all right. Mr. Pate, any questions now about what needs to go into the order?
Not at this time, Your Honor.
Okay. Ms. Pierce, do you have any questions about the court's orders made here today?
No, Your Honor.
Okay. I will determine what our next court date is. It appears to have been set on the PAC docket of October 23, 2023 at 2:30. Do you know at this juncture, Mr. Pate, whether he's going to want a preliminary hearing or not?
I don't yet, Your Honor. I've yet to be able to meet with them in person, and I'm not sure if we've got all the discovery yet,
Right.
but I.
Fair enough, counsel. That wasn't a decision that you were expected to make today. I just thought if you could announce it, we'd go ahead and address that step. But Mr. Shack, I will note that your next court date is 2:30 p.m. on October the 23rd. That will be a Zoom docket. If you're in jail, obviously the jail will take care of your participation. If you're not in jail, you need to appear at the Sallyport or Mr. Pate's office. Okay?
Your Honor.
All right. If there's nothing further in the Shack matter, it will be in recess at this time. And Mr. Pate, do you have just the one case?
Yes, Your Honor, and Mr. Shack is present at my office. Come around.
All right. Court will next call State of Kansas versus Glenn Shack, case number 2023 CR 435. Chris Pate appears as defense counsel. Glenn Shack appears in the office of his attorney, Mr. Pate. Appearing for the state apparently is Cheryl Pierce.
Yes, Your Honor.
This matter comes before the court at this time for further proceedings. Docket notes from September 20th indicate that a motion to reduce bond was granted. An electronic monitoring device requirement was added, including an appearance requirement at either at Mr. Pate's office or at the Judicial Center in El Dorado. Pate, I have something dated October 17 of 2023. Appears to be another motion to modify bond. And I trust that still needs to be heard, Mr. Pate?
It does, Your Honor.
All right, the court's already modified bond once. What's the request for modification this time?
Well, the issue that the court granted our bond And then when Mr. Shack bonded out, well, the court directed me to file an order modifying that bond, which I did. I prepared that order and filed it on September 26th with all the conditions the court set forth. Because the court ordered electronic monitoring, there was a separate electronic monitoring order that went out that I want to presume is just kind of a standard order that goes out in electronic monitoring cases, because I didn't prepare it. In that electronic monitoring order, it states that Mr. Shack is to have no contact with Mandy Shack, who is his wife, and also that he is to have no contact with True Lies, which was his employer. And I'm certain it went out that way because both of those entities are listed as endorsed state witnesses. And I've reached out to Ms. Pierce about this issue in an effort to avoid having a hearing. But it was contemplated that Mr. Shack would have contact with those individuals because, number one, in my original motion to reduce bond, I noted he was employed at True Lies. And when I made my oral argument to modify bond to the court, I would have stated to the court, Mr. Shack is not a flight risk. He lives in El Dorado. He's going to live with his wife. And then the court made its order modifying the bond, specifically stated no contact with anybody under the age of 18, no pornography, restrictions to Butler and Sedgwick County only, and then to appear at Sallyport or my office court. So I'm asking that the no contact be lifted between True Lies, because that's where my client would still like to work, and with his wife, because it's his wife, with any appropriate orders that they not discuss the case. But it's, my client hasn't been able to go pick up, I think, a paycheck or two still from True Lies because he can't contact them and he can't go home because of this order. And I really do think it was just kind of a standard order that went out. I'm not intending to read the court's mind, but I think I was clear to the court that Mr. Shack would want to live with his wife.
Are there any children under 18 living in Mandy Shack's home?
No.
Okay, Mr. Shack's answering that, but I'll take that at face value at this point. Does the state oppose this modification of the bond that's being sought here?
No, Your Honor. Mr. Haight did the order modifying the bond, and I guess if he had specified or wanted that specified in the order, he could have done it at that time. But maybe it was an oversight by him, maybe it was an oversight by all of us. But she is an endorsed witness, but her statements are recorded. So I think that if need be, she can be appropriately questioned about those statements. So I don't have a problem with that.
And just,
the court will
and I
grant your
just,
request, Mr. Pate.
okay.
The restrictions on the electronic monitoring order, which would appear to preclude contact with Mandy Shack or True Lies, are removed. Appropriate contact with both entities can take place, Mr. Shack. And you'll probably need to do an additional order and make sure it gets to the electronic monitoring program, Mr. Pate.
I will, Your Honor. And like, I think the issue, there was a separate electronic monitoring order that I didn't prepare, but I'll get that taken care of and I guess emailed to the court for signature after Cheryl approves.
That's fine with me.
You send it to my assistant, Mr. Pate.
Yes, Your Honor.
All right. What announcement is made regarding preliminary hearing right in this case?
Your Honor, I just received discovery on this case, I believe Monday or Tuesday last week. I can't really speak to the delay. For that reason, I'm not prepared to announce one way or another whether we need a preliminary hearing. I'd request a continuance for another PHC setting. If the court's not inclined to grant that, and we need to set a preliminary hearing, I would ask it be quite a ways out due to the presumed volume of discovery that was sent over.
How much time would it take to do the preliminary hearing in this case, in your estimation, Ms. Pierce?
Couple of hours, Judge. Yeah, I believe that'll work, Judge.
Very well. The Shack evidentiary hearing will be set for Monday, December the 11th, 10 o'clock to noon. Mr. Shack must fully participate in that hearing at that time. Counsel, just given the subject matter of this case, I'm going to conduct this as an in-person hearing. I think that we'd have too many issues with the display of exhibits on Zoom. So this will be an in-person proceeding. Mr. Shack, you have to be at the Butler County Judicial Center for this hearing. 10 o'clock, Monday, December the 11th. Look forward to receiving your order, which modifies the bond in the manner in which we've talked about here today. Is there anything else we need to address currently on Shack, Ms. Pierce?
Not by the state, Your Honor.
Mr. Pate?
No, Your Honor.
Very well. Then the Glenn Shack matter will currently be in recess. Move on to another matter. This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Glenn Edwin Shack. It's case number 2023 CR 435. Cheryl Pierce for the state of Kansas, Christopher Pate as defense counsel, defendant Shack appearing in the office of his attorney, Mr. Pate. This matter comes before the court at this time for a hearing that was scheduled and added to the court's calendar. I will note that the matter had come before the court on October the 23rd. At that time, the court granted a request to set the preliminary hearing on December the 15th at 10 o'clock for an in-person proceeding. Mr. Pate, what is the nature of today's proceeding?
Well, there's a couple of issues, Your Honor. Ms. Pierce contacted me about 3 weeks ago and informed me that the state was going to be filing additional charges. I have an appointment set up with Detective Gatz on the 27th of this month to review that evidence. So I was initially requesting additional time for that. However, I had in my notes that this was scheduled for a preliminary hearing on December 11th. And I think Ms. Pierce did as well, because both she and I have been set for months to be in an in-person termination hearing, both the 14th and 15th. So I'm not sure where we got our wires crossed, but I think that's the same date Cheryl had as well.
It's possible that there was an original setting on the 11th. Some reason we moved it to the 15th, though it was apparently all done on October 23rd in everyone's presence, at least if I can have any confidence in my docket notes here. Ms. Pierce, your position here?
Judge, I did in fact add some additional charges. I did notify Mr. Pate of the same. I did kind of send out a email, if everyone recalls, that I had done that and that we might want to reschedule the preliminary hearing. That would give Mr. Pate time to get in there and view those images. And as far as the scheduling, Mr. Pate is right. I had it originally scheduled for the 11th. I had sent out subpoenas to the same. So I don't know what happened. I don't know how Mr. Pate and I got our dates fouled up, but we did. And we are scheduled in a 1.5 day long termination in front of Judge Lee on the 14th and the 15th. So I would ask that we continue this joint request for a continuance, allow Mr. Pate time to get in there and view this. We have preliminarily talked about something short of a trial, a plea. We're not anywhere near ready to do that, but we have opened that door some so that we can perhaps, after Mr. Pate gets a little further down the road, come to some agreement short of a preliminary hearing. But that's the state's position, Your Honor.
I'll just note that this is the fourth time that this case has come before the court, and we're still not anywhere near, apparently, of getting through a probable cause determination. And Mr. Payne, I'll just share with you what I think I've shared with you before, that this court doesn't believe that the fact that you haven't seen full discovery holds up a preliminary hearing. After all, the very purpose of a preliminary hearing is for the state to show the defendant that there is evidence to show probable cause that a felony crime has been committed and that he committed it. So the fact, and I don't think that there's any requirement under any statute that requires you to have had discovery even provided to you prior to a probable cause determination. So the court will deny the continuance request for that reason. However, noting apparently that this case was originally set for December the 11th, I do note that my paper calendar reflects that there was a setting on that date crossed off. I also show it on the 15th. I can kind of see where perhaps the December 11th date came from, and I don't know exactly at what point the case was moved from the 11th to the 15th, but it was all included in my docket notes from October the 23rd. Perhaps right after our court proceedings, somehow someone realized a conflict and asked for it to be moved. For the reason that apparently both attorneys in this case are committed to a matter set in another court, the court is inclined to grant the continuance request for that reason and that reason only. I also note that Mr. Schack is out on bond and therefore would not appear to be materially compromised by what the court views as just further delay. Counsel, can we agree on a date that we can go ahead with the evidence in this case and get through it and have a probable cause determination?
Yes.
Yes.
How much time are you really anticipating now, given your second amended charging document and the number of felony charges continue to grow? So how much time is the state going to need to present evidence to show probable cause on these various matters?
Judge, I would suggest that we have at least the morning or an afternoon.
Thursday, January the 18th, starting at 1 o'clock. And
That
I'll just
works
let
for me.
counsel know that I do have duty assignment in Butler County on that date. Now, that's not a first appearance date, but I may have to take a break at some point to address any matter that might come up that requires my attention. I would generally be taking a recess at some point in the afternoon anyway, but I'll propose a 1 o'clock p.m. start on Thursday, January 18th. Ms. Pierce.
And just 1 minute, Judge. Tuesdays and Thursdays are usually my juvenile docket, but I do have somebody that can cover. So I will take that. It looks like there's not too much on that docket or not anything on that docket day. So so I'll take it.
Mr. Pate.
That works for me in person, correct?
Correct. Court will reset the evidentiary preliminary hearing in the Schack case to Thursday, January the 18th, starting at 1 o'clock p.m. in person, courtroom B, Butler County Judicial Center. Mr. Schack,
Okay.
I need you to check into security before 1 o'clock. I want to make sure that we can get started promptly at 1 o'clock p.m. that day.
Yes, Your Honor.
All right. Mr. Pate, is there anything else we need to address currently?
Your Honor, Mr. Schack had requested that I ask the court to review his bond conditions. He's been out on bond since approximately October 1st. He's on a $50,000 cash or surety bond with EMD and travel restriction to Butler and Sedgwick County only. He was wanting the court to consider easing that travel restriction if it involves work-related travel, and also if the court would consider relieving him of the EMD requirement just because of the cost aspect of that. He's certainly glad to be out and appreciative of the earlier bond reduction the court gave him, but at this time he would make those requests, and I can tell the court he's been in good contact with me during the whole time he's been out on bond.
Pierce, your position on those relaxation of restrictions requests?
Judge, I would object to any further modifications to his bond or his EMD. He is not only looking at what are off-grid felonies, we've added several level 5 felonies as well. We are up to 9 different counts of possession or internet trading of child pornography. We started out with $100,000 cash or surety bond. We went to a $50,000 with EMD with modification that it could go to Butler and Sedgwick County for the purposes of work. My understanding is that he works at True Lies. You modified his bond again on October 23rd to allow him to have contact with his wife as well as his employer. I think the court has allowed multiple modifications to assist the defendant in getting a job, holding down a job, being able to work through this, the pendency of this case, and move around quite freely. So I think that the court has made significant modifications and would ask the court to deny the request.
Mr. Pate, any reply argument?
He's not working at True Lies. He's working remodeling over here.
Well, finished carpentry.
I think he's actually prohibited from having contact with True Lies at this point.
No. No, the court relaxed that restriction on October 23rd.
Okay. But he is not employed there at this time.
I agree with Ms. Pierce. I think that the bond was lowered substantially in contemplation that he would be on electronic monitoring, and the fact that his geographical location would be restricted to just Butler County, obviously this county, or Sedgwick, which happened to be the where his attorney's office is. It's the intention of the court to maintain those restrictions in place. I think that was all contemplated when the bond was lowered. And the court will deny the request for further modification at this time. Preliminary hearing is set for 1 o'clock, Thursday, January the 18th, in person.
Okay.
If there's nothing further then, the Glenn Edwin Shack matter will currently be in recess, and this meeting may be ended for all.
Thank you, Your Honor.
Thank you.
All right, I regret the delay, counsel. Glenn Edward Shack. I see a box with Glenn Edwin Shack on it, but I don't see Mr. Shack.
Glenn, can you hear us?
You have any idea about why he's not on the meeting with us, Mr. Pate?
I don't, Your Honor. I talked to him just about 30 minutes ago on the phone. I don't know if he's having some technical issues as well. I can try calling him.
Please do so.
He's going to log out and log back in. He said he can see and hear us, but he can't access the audio. He's logging out and logging back in, Judge.
All right, can you hear me now?
I can hear you. I can't see you though.
Okay. Yeah, hold on here. See something real quick.
Should be a video button bottom left.
There we go. Okay, start video. All right, can you see me now? There we go.
Okay.
Mr. Devaney?
Yes, Your Honor.
We'll call the case. This is State of Kansas versus Glenn Edwin Shack. It's case number 2023 CR 435. Darren Devaney appears as Butler County Attorney for the state of Kansas. Chris Pate appears as defense counsel by separate Zoom from his client, Glenn Shack, who apparently appears on his own Zoom. Counsel, you'll need to explain something to the court. I will just note from my docket notes from April the 11th that the defendant had pled no contest to counts 4, 5, and 6, level 5 sexual exploitation of a child felonies. At that time, a pre-sentence report was ordered. Sentencing was set for today in person in courtroom B at the Butler County Judicial Center in El Dorado. As the court recalls, my office had a discussion, I believe, with the attorneys involved in this case, perhaps by telephone or perhaps by email communication, with an apparent report that Mr. Shack had been picked up and sent to the state of Texas and was incarcerated in a jail facility there. Based on the representation that he was in custody in the state of Texas, I believe this court gave permission to convert this case from in-person in El Dorado, Kansas, to doing this by Zoom. However, I note Mr. Shack appears to be in a car, and he is not in custody in a Texas facility. Mr. Pate, do you have an explanation for this?
I do, Your Honor. Mr. Shack was arrested April 24th. He was held in Sedgwick County, and then he was extradited to Texas around May 22nd. Mr. Shack made bond last week, and then he contacted my office to let me know he'd made bond. He has not made his first appearance down there, as I understand. One of the conditions of his bond is that he not leave the state of Texas until he makes his first appearance.
When is this first appearance in Texas?
And Mr. Shack told me he is waiting on his attorney to provide him that date. He
That wasn't provided to him when he bonded out in the state of Texas?
No.
I asked him that exact question, Your Honor, and that's exactly what he told me, which I agree
counsel,
sounds very
this situation is unacceptable to the court. This court clearly contemplated that Mr. Shack would be in the courtroom here in El Dorado for this sentencing, and only based on a representation that he was in actual custody in a correctional facility in the state of Texas, in other words, a county jail. This court allowed a meeting to be set up by Zoom so that we could conduct sentencing proceedings because he was in custody. He's running free in the state of Texas. He should be here for his sentencing in this case. Quite frankly, this court doesn't care that he's been ordered or supposedly under some restriction not to leave the state of Texas. He has obligations to the state of Kansas on 3 child-related sex felonies to be here for sentencing. And he is not kept from being here by being incarcerated. And then apparently, I don't understand a bizarre system that would bond somebody out without a court date. I mean, are they not going to charge him? Is there not some movement here to actually prosecute the case in Texas? And if so, why is he restricted from leaving the state if no judge has ordered him? If he hasn't seen a judge on bond, he hasn't even made a first appearance, why is he under this stay in Texas restriction? Mr. Pate, can you explain that?
That's what Mr. Shack told me. I spoke with him by email yesterday. I was actually out of the office, out of the state for a good part of yesterday, and was communicating with Mr. Shack as best I could. And that's the best explanation I have, Your Honor. I don't know if he has bond paperwork. Do you have bond paperwork, Glenn?
No, I do not. It was because I skipped bond from a year and a half ago when I got into a fight. That's what this is from. I don't understand how a fist fight can be more
Well,
important than
and
what we had
and
going on
that
in camp.
and that part is neither here nor there. He's just
Right.
operating under what he was told, that he can't leave the
Yeah.
state of Texas until he makes his next court appearance. And I appreciate the court's order. I was not comfortable telling Mr. Shack, hop in a car and drive up to Kansas and risk violating your bond and getting yet another warrant in Texas. I certainly understand why the court would want to conduct a sentencing on level 5 felonies in person. And if we need to set this for a new sentencing date so everybody can be in person, I certainly think that would be appropriate as well.
Court will reset this case for sentencing. The court finds the current situation unacceptable. And I will order an in-person sentencing since Mr. Shack's obviously not in custody of a jail for a date to be determined. I'm going to presuppose that there's going to be at least a first appearance on the Texas case within the next several weeks. Though I apparently don't have an understanding of the criminal justice system in Texas. And I will order Mr. Shack to surrender himself to the Butler County Jail because I'm going to suspend the operation of his Kansas bond at this juncture. The court was willing to waive his non-appearance in court in person as he was ordered to do, only based on the fact that he was incarcerated. I have no documentation before the court that he is restricted on his movements in Texas. Further, he's free as far as the court's concerned. And I've become quite insecure about Mr. Shack. I find out now that he jumped bail in Texas, which led to him being picked up in Kansas. And I don't understand why he was sent to Texas before Kansas was done with him. Just a couple of weeks more, and he could have had his case done here. But nevertheless, we are where we are. As far as I'm concerned, you're an absconder at this point. Mr. Shack, you've left the state of Kansas. You didn't appear in court as you were ordered to do. You're not on bond in Kansas as far as I'm concerned. My order to you is come to Kansas, surrender to the Butler County Jail, and be held there until you can be transported to our courthouse and be sentenced in person.
Yes, Your Honor.
Looking for an appropriate date. Mr. Pate, Mr. Devaney, if you're going to be covering sentencing for your office, would you look for Monday, June 24th, after the normal afternoon docket, 4:00 p.m. is what I'm looking at.
I'm out of the office that week, Your Honor. I think I'm going to be in person in your courtroom July 3rd in the morning for the McCoy sentencing, if there's any time available then.
Not that morning, but I could work setting in after afternoon docket on that date, Mr.
Okay.
Pate.
Any time in the afternoon is open.
3:00 p.m. Wednesday, July 3rd. July 3 at 3. However, I will state, in light of the court's order suspending bond in this case, if Mr. Shack is taken into custody and is present in Butler County, we might look at trying to get the attorneys to coordinate an earlier date for sentencing. Since he will be on a no bond hold once he's picked up here. I'm open-minded to trying to find an appropriate alternative date, but for now, we'll have sentencing reset to Wednesday, July 3 at 3 o'clock in the afternoon, in person, courtroom B, here in El Dorado, Kansas. Your duty, Mr. Shack, is to get yourself here. Surrender to the jail.
Yes, Your Honor.
All right, Mr. Devaney, from prosecutor's perspective, is there anything else that we need to address currently?
I don't think so, Your Honor, other than, I mean, obviously there's the procedural backstory here too, which was he was picked up in Sedgwick County, apparently on that active Texas bond. I have no idea how he was extradited even back to Texas without a governor's warrant in some of these matters. So I feel like that was
Probably waived extradition, I presume.
Very well could have. And I don't know how long that warrant was issued or how long that sat in the system, but at this point, my feeling is if we can get Mr. Shack back here to Butler County, I'll make sure to contact the sheriff's office and let them know that there's no waiver, there's no return to Texas until we can get this case sentenced. Make sure that this is a primary case at this point. I'll also be in contact with the bondsman. Looks like it's second chance out of Wichita, but I'll let them know about the orders of the court here today.
All right. Anything further from your side, Mr. Pate?
I'd just like a breakout room with Mr. Shack after the hearing's over. I want to get his attorney's information down in Texas.
We'll try to accommodate that, Mr. Pate. If you and Mr. Shack can remain on the meeting after we formally recess, we'll try to allow that to happen. All right. If there's nothing further at this time, the Glenn Edwin Shack matter will be in recess. The court will stop recording and broadcasting on this case at this time. We'll leave the meeting open for the session for the attorney and client.